All right, does the defense rest at this time?
Yes, Your Honor.
Okay, does the state have any rebuttal evidence?
Very brief, Your Honor. First witness we would call would be Detective Ryan Prock. Detective Prock, as part of your work, you've reviewed the extractions from Alex Woodworth's devices.
That is correct.
Does that include reviewing the extractions from his cell phone?
Yes.
Did you review those extractions as it relates to text messages that Alex Woodworth received that were on that phone?
Yes, I did.
Did you see any text messages on March 5th of 2018?
There were text messages on March 5th.
Specifically, did you see a text message from John Hansen?
I saw one.
Irrelevant. Can we approach, Judge?
All right, objection is sustained.
And just so that it's clear, the text was on March 6th from Hansen?
That is correct.
And was that shortly after that these searches on Facebook occurred involving the defendant and Jason Mengel?
It was.
All right. Now, Detective, when you interviewed the defendant on March 24th of 2018, had the autopsy been completed yet of Alex Woodworth?
No, the autopsy was going on at the same time as the interview.
And you were at the scene on March 23rd when Alex Woodworth's body was found, correct?
That is correct.
Right. At that time, and prior to interviewing the defendant, which of Alex's wounds were you aware of?
I knew of the wound to the side of his head. I knew of his throat wound, in particular the cut, the slash mark wound. And then I knew there was a large amount of blood in his groin crotch area.
All right. Outside of that, did you know of any of the other injuries?
No, I did not.
Sustained? All right. Thank you. I think that's it, right? That's all I have, Your Honor. Thank you.
Okay, any cross related to just those specific areas?
When you were I want to ask you some questions about your being at the scene on the 23rd of March.
Okay.
That's the date that you went and saw the car and saw Alex Woodworth in the car, is that right?
That is correct.
How long were you, and that was, just to put it into context, on the 23rd, you, at some point chronologically, you met with Ezra McCandless, is that right?
That is correct.
After that, you went to go speak with Farmer Sipple, right?
I went and spoke with Mr. Sipple, yes.
And then after that, while you were ending that up or sometime during that, you got the call from Piper that they'd found footprints.
Yes, Sergeant Piper got a hold of me.
And that's when you then, at some point that day, after those events that we just talked about, you went and observed the car and Mr. Woodworth in the car, right?
That is correct.
How long were you there at the scene by the car?
I couldn't put a time on it.
You stayed there during the processing while the crime lab came, while other people came?
No.
Okay, did you leave before the crime lab appeared?
Yes.
Did you leave before it got dark out?
No. Well, are you talking about up by the car or are you talking out by the road?
Maybe this is, were you there, at some point Mr. Woodworth's body was taken out of the car and put on was taken out of the car. Is that right?
That is correct.
Were you there in general, not there to watch that, but were you there in general when that happened?
I don't believe I was on the scene at that time, no.
You had already left?
That is correct.
Okay. Had you gone back to the scene on the 24th at all, other than what you just talked about, prior to your talking to Ms. McCandless on the 24th?
You're talking about back to,
So on the 23rd, you were at the scene,
yes,
and then you left the scene.
correct.
And then on the 24th, you spoke with Ms. McCandless.
That is correct.
In between the time that you were at the scene on the 23rd until the time that you spoke with Ms. McCandless on the 24th, during that time, did you go back to the scene?
I do not believe I did, no.
Okay. When you say you do not believe you did,
I don't believe I went back there.
you use the word believe. Is there some hesitation?
Well-
You haven't used that before, and so.
No, I did not go back to the scene.
Okay. Did you, during that time period, have conversations or contact with officers who were at the scene?
I had a lot of conversations, and I don't know which investigators from Dunn County were or were not at the scene, so I couldn't say that. I would assume I spoke with somebody from the scene.
On the 24th, when you met with Ms. McCandless, that was late in the afternoon?
No, that was in the morning, I believe.
Well, I'll just ask this. What time was that?
I couldn't give you an exact time.
Okay. In the morning at 8 a.m., in the morning at 11 a.m., or you just don't know?
It was between 8 and 10 a.m. I couldn't give you an exact minute, hour, half hour. It was between that time frame.
Okay. And in that, you know when you left the scene on the 23rd?
Yes.
What time did you leave the scene on the 23rd?
Oh, I don't know what time I left. It was dark, and after that, I went into Dunn County's sheriff's office.
Okay. And then on the 24th, before you met with Ms. McCandless, did you go and speak with anybody in person at the Dunn County Sheriff's Department?
Investigator Conkey met me at Mayo Health System.
All right. And that's where you met eventually with Ms. McCandless, right?
That is correct.
Prior to your, during that meeting with Mr. Conkey, did he inform you of the investigation, what had been going on at the scene, get you up to date about the processing of the scene?
I don't remember what our specific conversation was about.
Okay. You were here in court and saw some of the pictures from the scene, is that right?
Yes,
And you saw there was the picture of Mr. Woodworth at the scene in which his shirt was pulled up and there was, can't remember what the wound number was, but I think it's wound number 16 in the autopsy report. The wound on his back side by the ribs was visible. Do you remember seeing that picture in court?
I remember that picture.
Did Investigator Conkey tell you about the wounds that he had knowledge of prior to your meeting with Ms. McCandless?
I don't remember what he told me specifically, no.
Okay, so he might have, he might not have, you don't have a independent memory right now whether he did or whether he did not. Agreed?
I just remember the wounds that I knew about, and
I'm not asking you about that, sir. I'm asking you about what Mr. Conkey may or may not have told you. It sounds to me like you say you don't have a memory of what he told you on that day. Agreed?
I don't remember what he told me, no.
All right, thank you.
All right, any redirect?
No, Your Honor.
Okay, Detective Prock, you may step down. Thank you. And the state have any additional witnesses?
Very briefly, the state calls Julia Post to the stand. Can you please state and spell your name for the record?
Julia Post, Juliapost.
And do you know the defendant, Ezra McCandless?
Yes,
How long have you known her?
since grade school.
And did you go to school with her through middle school, high school?
Yes,
And were you friends with the defendant?
yes,
Do you have an opinion as to the defendant's character for truthfulness or untruthfulness?
yes, I do.
And what is that opinion?
They are not very truthful.
I have no further questions.
All right, any cross-examination?
Yes. You knew Ms. McCandless from elementary school.
Yes,
You rode the bus together, right?
yes,
As little kids.
yes,
And then you went to middle school with her, right?
yes,
and you know her from middle school, right?
Yes.
And then eventually, you guys were classmates in high school, right?
Yes.
She went away to college in Marinette. Agreed?
Yes.
You stayed in the area and went to college in Eau Claire.
Yes.
During that time, you didn't have much, if any, contact. Agreed?
Yes.
Your contact that you've had with Ms. McCandless is basically from the bus in elementary school, from middle school, and from high school, right?
No.
Well, she was in Marinette, you were in Eau Claire, you didn't have much contact, you just agreed with that, right?
Yes.
And then after that, when she came the next year in the summer of 2017, fall of 2017, Ms. McCandless was in the Eau Claire area, correct?
Yes.
You were going to school, right?
Yes.
She wasn't going to school, agreed?
Yes.
You didn't have much contact, you weren't in the same friend group, agreed?
Yes.
So your contact with her up until a particular day in March of 2018 was really from elementary school, middle school, and high school, agreed?
No.
So other than high school, post-high school, you had contact with her on one day in March of 2018, right?
No.
You saw her in March of 2018, right?
Yes.
She came to your house.
Yes.
She was a friend of yours.
Yes.
She brought her journals.
Yes.
You looked at her journals.
Yes.
You edited or did edit, but you looked at over them from grammatical standpoint, correct?
Yes.
She was pretty relaxed about it, right?
Objection, this exceeds the scope.
Sustained.
Judge, this is 906-16 about her opinion. I'm able to do that under 906-16. I believe it's Alaska v. Davis. I don't have the Supreme Court site, but
Give me a sec. Now, 616 goes to bias. That question was asking about her opinion about her mood.
I
Or
believe it goes to bias and it goes to credibility. This witness has offered an opinion. I am asking questions to see what foundation, if any, she has for that opinion, and that's part of the bias that you're able to bring up. I've cross-examined her and said she had contact in elementary school, she had contact in middle school, she has contact in high school. After that, she says she's not had any contact, yet when I ask her about her opinion, she says it's based on something beyond these middle school, high school years. And so,
Okay, well, you can ask that. I don't have a problem with that, but I'm sustaining that specific question, or objection to that specific question. So you may continue.
you spoke with the police after you learned about the death of Alex Woodworth, is that right?
Objection, again, exceeds the scope.
It's going to establish the questions that I'm going to ask her, Your Honor.
Overrule that objection. You may continue.
You spoke with the police about Ezra McCandless after you learned about the death of Alex Woodworth, right?
Yes.
And you know those conversations were all recorded. You know that, right?
Yes.
And there's reports about those, correct?
Yes.
And what you told the police was, let me make sure I get it correct.
Your Honor, can we have a sidebar on this, ma'am?
All right, Counsel Approach.
When you spoke with the police, you told the police that your parents didn't like you being with Ezra. Is that right?
Yes.
Yet, you were with Ezra in March of 2018, right?
Yes.
And then you found out that this person who your parents said they don't want you to be with was accused of homicide, right?
Yes.
And you've read about that in the papers.
Yes.
You've watched news about it, correct? You've never seen anything on the news about it in any way?
You have to answer out loud. I know you're shaking your head. Does that?
No, I have not.
Okay, but you have read articles in print or digital versions of written articles?
Yes.
And you've gossiped about it with your parents?
Yes.
You've gossiped about it with friends in Eau Claire?
Define gossip.
You've spoke about things that you don't know about with your friends in Eau Claire regarding the charges against Ezra McCandless, right?
Yes.
You weren't there on March 22nd, were you?
Can you redefine gossip for me? I'm sorry.
I think you've answered the question. You don't have facts about March 22nd that you can offer here about what you saw, what you heard, what you felt, what you smelled about what happened on March 22nd between Ezra McCandless and Alexander Woodworth, right?
Yes.
You haven't read police reports?
No.
You haven't read medical reports,
No.
crime lab reports?
No.
You haven't seen any photos from the scene?
No.
Spoke to psychologists?
No.
Any other experts about it?
No.
You haven't been here in trial watching this in any way?
No.
You haven't been watching it on court TV or any other news media during this?
No.
So you don't know anything about what's going on in the trial?
No.
You just have an opinion about a person you knew in middle school and high school. That's what you're here to offer.
Objection, that's misstating the evidence.
Well, it is misstating the evidence. I'll sustain that.
You're here to offer an opinion about a friend from middle school. Agreed?
Objection, asked and answered.
Sustained.
That's all.
Any redirect?
Ms. Post, did you have an opinion about the defendant's truthfulness before you saw the articles in the news or before this came out on March 22nd, 2018?
Yes.
And what was that opinion?
My opinion was that this person is not very truthful.
Nothing else.
Okay. Any recross?
So you're telling this jury that prior to March 22nd, you had these opinions about Ezra McCandless, correct?
Yes.
Yet on March 23rd, you went to the hospital and met with her, this person who you say you have this opinion about, right?
Yes.
Nothing else.
Okay. You may step down. Thank you. And I believe Ms. Post could be excused.
Yes.
Any additional evidence from the state?
No.
All right. Any rebuttal from the defense?
No, Your Honor.
All right, ladies and gentlemen, both parties have rested. We have quite a bit of work to do for jury instructions. And rather than to have you wait for hours here and then for there to be arguments late in the day and give the case to you this evening, as I'd indicated yesterday, the plan is for us to do that work, which is, again, we expect a jury instruction conference could take as long as 3 to 4 hours. And so we're going to excuse you for the day. And then I just ask that you be prepared, bring an overnight bag tomorrow, and be here by 8:30. And, it seems like there's always an issue that comes up that delays things a little bit, but if I want you here to be able to start with instructions and then closing arguments beginning at 8:30 a.m. tomorrow on Friday. Again, I gave you the instruction. We call it part of 150 yesterday. And I'm just going to reiterate, I've read it to you a number of times, just to remind you, it's extremely important that you make your decision in this case based solely on the evidence offered and received at trial. There will be extensive instructions about evidence and so forth in the instructions. But again, you're not to discuss the case either among yourselves or with anyone else. Don't let anyone talk to you about this case or try to influence your opinion in any way. Do not look at any form of media, newspapers, television, social media, internet, news, or any other way. Do not, again, do any research with any on or off of a computer regarding any of the parties. or this case or publicity and so on and so forth. Again, it's very important that you jurors who have been selected for this very important duty decide the case, again, based only on the evidence received by the court pursuant to the rules of evidence in this state, and the instructions on the law that the court will give you. And again, that, as you can probably tell by now, this is a complicated case. And here's, and I don't want to make the attorneys too nervous here, but I just want to improvise here a little bit. When you get into the subject that you have in this case, there's a lot of movies, television shows. Every state has maybe different terminology and so on and so forth. Even Wisconsin did a major revision of its homicide statutes in 1988. So even in Wisconsin, different things were called by different names. So what's important, and you have to trust that this court and these attorneys are working hard to make sure that you are properly instructed on the law of Wisconsin as it exists today. And that's another thing, that the danger of commentary from other places, and I hope everybody's following those instructions the court has given you so far, but the law is different in different places, and people talking about this case don't necessarily know what the law is here and what the decisions are here. And so it's important, in order to do your duty, that you wait for any discussion or consideration until you've actually heard what you are to decide and what the law is that will be presented to you for your decision. You will, again, be given detailed instructions, and it's, and I tell you, a fairly big project. We have to go over it word for word, and the law requires that we do that on the record. We'll do some off the record, but ultimately, in every case, there has to be a formal jury instruction conference on the record. We try to be as efficient as possible, but in a case where we've had several days, this is day 14. We've had 13 days, 12 and a half days of testimony. So there are a lot of issues. And so I just ask that you be patient and that you understand that. You all took an oath at the beginning of this case that you would make your decision based upon the evidence that's received in this courtroom and on the instructions the law gives you. And so now is a very important point where you get a little time off today, and I want you can rest, process what you've yourselves, what you've seen or heard, and then hope that you be fresh tomorrow morning, and the attorneys will be fresh and have an opportunity again to make sure that everybody's prepared for this very important part of this trial, that being the instructions and the closing arguments of counsel. Again, one of the things I do still have to take up with counsel is whether you would be sequestered. It used to be the law in this state that it was mandatory to sequester a jury once they've been sworn in a case of this nature. And that's no longer required by the law. But and one of the questions that we have to consider is, how late you jurors may want to deliberate and into the evening, and whether you'd be more comfortable being able to be at your own homes, or if you do not reach a verdict, to be able to go home overnight. And we have to think about those sorts of things, how late we would have you go. And frankly, we want to give you as a jury some input on that. So we'll take that up as you begin your deliberations.
Judge, could we approach about that issue? I think there may be some answers that we could give you just very briefly.
Okay, who is someone on the part of the state? Okay. Well, ladies and gentlemen, I can tell you that, again, parties are not asking for sequestration. So, again, this is something that it's very important that all of you, follow those instructions that I've given you and we've talked about every day, so that you're not improperly influenced in any way and that you decide this case on the evidence and the law. Okay?